Just looking at the legal side of this case of the 7-year-old child who was allegedly raped in the Eastern Cape, it's alleged that the school principal in this case is refusing to provide the authorities with his DNA samples. Can one refuse to cooperate with the police after they have been identified as a person of interest? These are just one of the questions we'll like our legal analyst, Mpumelelo Zikalala, to unpack this afternoon. Mpumelelo, very good afternoon to you, and thank you so much for your time. So let's start with that question. So can one refuse to cooperate with police after they've been identified as a person of interest? We don't know at this stage if he is a suspect. I mean, we know, of course, that there are those that are saying that there is a DNA test. So there are those prescripts which police can act within. So just give us an understanding. Where does this all lie?
Mm-hmm. Good afternoon to you and also to your viewers. Yes, you can refuse, but if you do refuse, you then have Section 36 capital E, that takes care of that, in which the police can then come in and say, we are not describing you as a suspect, we are only describing you as a person of interest, and we need your DNA sample so that you can go and do further investigation, and then we'll take it from there. What is required if you then refuse is an application for a warrant, which is going to be issued either by a magistrate or by a judge, which will then authorize the SABC to go and take this sample, which is so required by force, so that the police can go and continue with their investigation. So the refusal is, from my side, is purely cosmetic, because it's something that the police ought to have done a long time ago, ought to have done and collected it, so that you are able to eliminate and bring the investigation to finality.
Is there something that we are perhaps missing here? Because, I mean, there are all these legal implications. We understand, of course, that the principal has now got representation. Some reports saying AfriForum, of course, we heard also from them in terms of that statement. But wherein does the law lie now? If this case happened in October, we're now in April. Where should the police then start with this particular case?
I think it's a classic case of where the SAPS in this case might have dropped the ball in terms of doing the proper and thorough investigation. The Criminal Procedure Act is there, and for everyone to know what are the rights and the implications of refusal for any DNA sample to be taken. In fact, the Criminal Procedure Act also goes further to explain to the police, if you want to conduct investigations of this nature, what is it that you need to do? In fact, if you look at how the Department of Justice have dealt with cases such as these ones, with the introduction of Tutuzela centers, it will tell you that it views, or the government views, these rape cases as very important and matters that should be investigated and resolved within the shortest amount of time. So this is purely at the hands and feet of the police in terms of them doing the investigation. But not all is lost, because remember that when the child was taken to the doctor initially, there must have been ought to have been samples that would have been taken. There are reports that ought to have been there. So if you go and you conduct this DNA test and collect those samples now, you'll still be able to conduct that investigation, be able to continue with it. What is more surprising is that the matter has been going on for plus minus 3 or 4 days, and there's still no sample that has been taken from all the alleged individuals that are there. Then the question is, why aren't the police going to take these samples? Because the law allows them to do so. Why are they afraid to deem a certain person as a person of interest or part of the individuals that are being investigated, despite the fact that they are represented? At the end of the day, this section allows for the police to conduct the investigation, and nothing's going to impede them, whether they have legal representation or not.
And I mean, in terms of the family and how it's looking at this particular case, given how the school has been responding to it, what are the legal steps that the family can take, notwithstanding, of course, the concerns around how the SAPS have handled this matter?
Well, the parents can come back and say to the school, we send our children to a school or to an establishment for safekeeping, out of the understanding that you're going to keep them safe. So if you're going to engage in individuals that end up through your vicarious liability or acting in this particular manner, causing harm to our kids, so we want to claim, to launch a civil claim against you, the amount that will be determined for the civil claim will be amounts have we suffered, for example, for hospital expenses, for expenses such as a psychologist and any other general damages and legal expenses that you would have gotten into. So there's definitely a claim against the school if you're able to prove, but it makes it easier for you to prove that claim on a civil basis when the criminal matter has been done and dusted, because it is investigating officers that are going to do the investigations for you, make sure that they're able to come back with a conviction. Probably individuals that are going to go and testify within this criminal trial, you can even use that particular evidence because it would have been stated under oath to beef up your case against the school at a later stage. So even though they can go after the school, that avenue is available to them, but it's much easier to do so after the criminal process has been done and dusted, and you're collecting information from there and continuing with your other civil litigation. But it is definitely an avenue which is available that the parents can do so at a later stage.
So what now then, for the police as they take this matter on? I mean, can some other entity, for instance, come on board in terms of, just representing the family and fast track this process? Because, of course, we know that at the moment it seems as though no one knows, their role in this matter.
Definitely. I think if a firm of attorneys would come in or someone would say, I want to represent this young girl, I want to make sure that we stand for justice, it could assist, especially with the manner in which the investigation has been conducted. Asking simple questions. If you are the police and you have all these, the Criminal Procedure Act and Section 36E are available to you, why aren't you utilizing? Can you please explain that to us? Is there any other outstanding information that would need to be dealt with in which you are not investigating? What has caused delays from October 2024 up until now, and what you're doing about it? You do so that you're able to cover 2 points. The first one is to say, I want to make sure that there's justice for my child. Secondly, if there's any negligence which has been occurred or orchestrated by the police, I want to be able to sue them at the end of the day for not handling this matter in a proper manner and not leading us to having the justice in which we require. So those are the avenues which would be available to them. But definitely, if they could have maybe legal representative, that legal rep will be able to go and do all these inquiries on their behalf and be able to get the answers which they so require and which I would deem that they've wanted to know about these answers since October 2024.
And I mean, very quickly, Mpumelelo, as we wrap up our conversation, how much of what has been said, including bringing in lobby group AfriForum again, will this have an impact on a case when it does eventually go to court? Because, I mean, if you listen to some of the reports that we are reporting about in terms of the lobby group AfriForum saying that it's not possible for the principal of Bergview College to have been involved in the rape of the little girl, because it then goes on to talk about the 3 campuses of the school, and that the principal at the time of this supposed incident was a few kilometers away, etc., etc. There's just so much that's already out there in the public domain. How much of that will have an impact then, should this then eventually go to court?
But for AfriForum to make that particular assertion, they must have been there. As it stands, they're just like you and I. They were not there. They are hearing this information from the person who was included. So if that's going to be the assertion, provide evidence which is going to prove so. Provide other collaborative evidence which is going to eliminate you from the list of suspects. What is that? That's DNA that you can be able to submit, and the DNA is going to exclude you if you have nothing to do with all the processes that have been there. So they may mention that I wasn't there on the day or I was a few kilometers away. It does not make a substantial defense that would warrant that the particular principal is eliminated or excluded on that basis only of where he was a few kilometers away from the whole investigation. So at the end of the day, it's the police who are supposed to do this investigation. They're supposed to come in, take the samples, eliminate individuals that are not part and parcel of it, and make sure that those individuals that are included in it, they've been brought in. And it baffles me as why, after so many days, when there's a Criminal Procedure Act that allows you to do so, you haven't collected the sample as to date, and you have to wait up until lobby groups and the whole of South Africa stands up and say, go and investigate this matter. The investigation is in the hands of the police, and the quality and the quantity of the evidence is going to depend how well they do this investigation. So now it's up to them as to how they're going to conduct it. But what they must know, the future of that little girl is within their hands, and the only way of making sure that they're able to secure it if they conduct this investigation in a proper manner and ensure that there's a proper conviction at the end of the day.
Especially because it is a Schedule 8 offence that we are speaking of. But thank you so much, Mpumelelo, for all your time. Really do appreciate it. Legal analyst there, Mpumelelo Zikalala, there for us.